Good evening, everybody. My name is Attorney Chris DeBerry. Welcome to another edition of my legal series called Legal Ease, my weekly presentation where I try to introduce you to a different topic on the law and answer questions that you might have concerning legal issues that may be relevant to what's going on in your life or someone else's that you know. I appreciate you taking the time to watch this presentation. It's really great, the questions and the feedback I get, and some of the criticism too, and I welcome it all. Please, if you like what you see or hear, please feel free to like, share, or comment below. And I said I value your comments and your opinions very, very much. It's very helpful to what I do. Now, today we're going to talk about something that you probably may have heard of, but may not be entirely sure of what it means. And that is the Florida's 1020 life law. And that is something that applies to the possession of firearms or their brandishing or their use when committing a forcible felony. And I'll get into a list of those felonies in a little bit. Now, in an effort to address violence within the state, the Florida legislature has enacted several programs within the state. There's one called the Three Strikes Violent Felony Offender Act. There's the Habitual Juvenile Offender Accountability Act. There's another called Operation Thugs, which is short for Taking Hoodlums Using Guns Seriously, as if we didn't already take them seriously. And basically, the Thugs program targets felons with warrants for violent crimes and violent history. But probably the most popular of those laws passed in recent years is going to be Florida's 1020 life law, which was passed in 1999. It was introduced by Governor Jeb Bush then as a campaign platform, and it was very, very popular. In fact, once he became governor, it was enacted into law, and was one of the things that he did that was actually very, very effective at reducing gun crime in the state of Florida. So Florida codifies this 1020 life law under Florida Statute 775.087, known informally as Florida's 1020 life law. And it is essentially a mandatory sentencing scheme in the state of Florida, and it concerns the use of firearms during the commission of forcible felonies such as aggravated assault or battery. Now, Florida statute's name comes from a set of three basic minimum sentences that it provides for. An ongoing public service announcement campaign actually accompanied the law since its passage, and went under the slogan, "Use a gun and you're done." And essentially what this law does is it enhances the mandatory penalties that would be applied in the commission of forcible felonies if you brandish the gun, meaning carry it on you. Meaning to first to carry it on you, second to brandish it, which would mean to take it out and show it, and third to fire the weapon. So those would be the three circumstances where 1020 life would apply. The law basically mandates that offenders be sentenced to the maximum amount allowable for the committed felony. And basically, when you have a 1020 application, 1020 life application, the sentence passed under 1020 life has to be served consecutively to any additional sentence that you may be facing. Now, that's kind of interesting because as a criminal defense attorney, at times we try to get our clients' sentences for multiple offenses run concurrently, which is usually something that under most circumstances, unless there's some factors mitigating against it, the court will allow for. However, these sentences will be passed consecutively, so they won't run concurrently at the same time and terminate while one is still pending or shortly thereafter, but simply they will run end to end, and there will be much longer sentences in most cases. So basically, the courts must impose the mandatory sentences and the convictions for committing or attempting to commit any of the following crimes. This is regardless of whether the weapon was an element of the crime. So this isn't like possession of a firearm or something like that. No, these are crimes that don't necessarily have possession of a weapon as one of their elements. But if you're in possession and brandish the weapon, fire the weapon while committing these crimes, then you have the enhanced minimum mandatory sentence. And the first of these is murder. So if you commit a murder, and during the course of committing the murder, you have the firearm, you show it, you brandish it, you fire it, then you are going to be facing the 25-year to life. Of course, murder could also carry with it a death sentence as well. Sexual battery is another example of one of the crimes. robbery, burglary, arson, aggravated assault, aggravated battery. Now, there's a difference between assault and battery. A lot of people think that when they've been hit that they've been assaulted. Now, the difference is this: an assault is where you have been placed in imminent fear of impending unwanted or illegal physical contact or harmful contact. Uh, so the assault is the imminent apprehension, not the actual contact. The battery is the actual contact. So you're not just placed in fear; you're actually hit or struck or something like that. So that would be your battery as opposed to your assault. Kidnapping is another one. Trying to escape, aircraft piracy, aggravated child abuse, aggravated abuse of an elderly or disabled adult. Now, I have a good deal of experience having prosecuted several child abuse cases, and every once in a while, you'd see that there was a weapon involved, and we had the advanced uh, sanctioning system of the 1020 life that we had to apply, and that was really back when it first came out. So I was one of the prosecutors that was freshly applying that law. Another case where if you're unlawfully throwing, placing, or discharging a destructive device or bomb, if you're carjacking, so if you're carjacking somebody and you have the gun and you show it, if you fire the gun to scare somebody, or then you're going to have the increased uh, sanction. Home invasion robbery is another one. Aggravated stalking, drug trafficking and capital importation of cocaine and other illegal drugs, and possession of a firearm by a felon. So under the 1020 life law, the courts must, it's not discretionary. Judges normally have broad discretion to fashion sentences and remedies when the statutes don't say that they're restricted. In this particular case, the courts are restricted in their ability to sentence as they may consider within their discretion. They have to impose the minimum mandatory law. So there would be a 10-year prison sentence on anyone convicted of committing or attempting to commit any of the felonies that we talked about, with certain exceptions, while they're armed with a firearm or destructive device. The second would be a 20-year term if the accused is proven to be guilty of the offense and fired the firearm, and that could be proven during the commission of the felony. So that's your 20. And of course, 25-year to life if the accused discharged the firearm and killed or seriously hurt somebody while committing the felony. So the courts impose a 3-year term instead of a 10-year term if the defendant is convicted of aggravated assault, possession of a firearm by a felon, or burglary or of a conveyance, which is a car or a boat or a vessel. If the firearm used in the felony is a semi-automatic, high-capacity box magazine or machine gun, then the minimum mandatory prison terms are 15 years, 20 years, and 25 years to life, depending upon the facts of the commission of the felony. Now, the 3-year minimum sentence provision for certain crimes does not apply in cases involving these firearms. So when you're carrying the repeating weapons, the high-capacity magazines, a machine gun, the 3-year minimum mandatory won't apply. They will apply the 15, 20, and 25 years to life. Also, enhanced penalties will apply for convictions involving these firearms, even if the underlying crime was not possession of a firearm by a felon. So courts have to impose the minimum sentence regardless of really of any mitigating circumstances, and no part of the sentences can be deferred or withheld, and the defendants aren't eligible for any discretionary early release other than pardon or clemency or conditional medical release before serving the minimum sentences. Now, the courts do have the discretion to depart from the sentencing guidelines, and by that I mean they have the ability, based upon evidence presented by a defendant, to depart from the minimum mandatory sentence only if the defendant is able to show that he was a youthful offender, and that has to be anybody that is under the age of 20 who commits this crime. Now, since 2000, this 1020 life law, has applied to 16 and 17-year-olds. They've actually been included in this as well. So, it's something to think about as well, because right now we've got people of all ages brandishing guns, using guns out in public. You have this vigilanteism. Well, they have to understand that while they think they may be doing something good, they may be technically committing a felony. And if doing it while possessing, brandishing, or firing a firearm, much less shooting somebody, they're going to have bigger problems than they probably imagine. So, like I talked about before, the 1020 life law comes from the three main mandatory sentencing. One, which is for producing a firearm during the commission of certain felonies, and it mandates at least a 10-year prison sentence. The second is firing one during the commission of those enumerated felonies, and it will give at least a 20-year prison sentence. And three, shooting someone mandates a sentence of 25 years to life, regardless of whether the victim is killed or simply injured. And of course, the sanction may be more severe depending on how the injured person does. So the maximum penalty is a life sentence unless the defendant is charged with a felony murder or first-degree murder, in which the case maximum, rather than be 25 years to life, could potentially be a death sentence. So obviously that's important to know. And in addition to the 1020 life rule itself, the law at that time also established or increased mandatory minimum sentences for other crimes, at least a 3-year sentence in prison for felons who are found to be in possession of a firearm, an automatic 3 years. So if you're a felon, you're a convicted felon, and your rights haven't been restored, you can't carry a firearm or face potentially 3 years in prison, as well as any other sanction that may apply. At least a 15-year prison sentence if the offender is in possession of a machine gun, or the felon's in possession of a semi-automatic gun with a high-capacity box magazine while they're committing one of the crimes listed under statute 775.087. There's at least a 3-year sentence for aggravated assault with a firearm, at least a 3-year prison sentence for aggravated assault on a police officer, and at least a 3-year sentence for aggravated assault on a person aged 65 years or older. So please respect your elders and don't hurt them when you have weapons on you. Don't hurt them at all. And at least a 5-year prison sentence for aggravated battery on an officer, police officer. And there's at least an 8-year sentence for possessing a machine gun or a semi-automatic firearm while committing any type of battery on an officer or aged 65-year or older person. So the police officers and the elderly are given special considerations. It also created minimum sentences for convicted drug traffickers. And drug offenses that warrant a mandatory sentence begin at the level of a 3-year prison term. But depending on the type of drug, the amount of it, and also whether the drugs resulted in anyone's death, the minimum penalties may increase to 7, 15, or 25 years to life or death. Like I stated before, the prosecution really is the only charging authority. They have the discretion on whether a person can be waived for the minimum mandatory. I said before that the courts have the ability to depart under the youthful offender status if it's proven to the court's satisfaction that a defendant qualifies as a youthful offender and must be under the age of 20. However, ultimately, the prosecutor, as far as what to charge a person with and mitigation of those charges, really is within the state's authority, the prosecution's authority. And once again, the only way the judge can do that would be the sentence could be sentenced as a youthful offender, which would cap the maximum penalty at 6 years of any prison sentence or any supervisory sentence. So, and once again, one of the qualifications for the youthful offender is they have to be under 20 years of age. So, and once again, as I stated before, I think I did that since 2000, the 1020 life law has been expanded to include juveniles who are 16 or 17 years old. So, you're not going to get off the hook because you're a juvenile if you possess a firearm and commit any of the forcible felonies I talked about before. Now, apparently that had been very, very effective, particularly when this law was first passed. I'm reading this off a statistic I have. According to the Florida Parole Commission, in 2000, there was a 26.4% decrease in violent gun-related crimes compared to 1998's statistics. And Florida's index crime rate for 2000, which is based on a variety of different crimes, had dropped 18% from the previous year and had reached its lowest level in 28 years. And that was all because of it's attributed to the 1020 life laws. And we have to credit Governor Bush for introducing that. It's a very effective program and one that's become very, very popular and fairly easy for people to understand. But that's pretty much it. That's really a primer on 1020 life. I mean, obviously certain circumstances can make it a little more complicated, but that's basically how it works. You brandish a weapon during commission of a forcible felony, you get an automatic 10 years on top of any other sentence that may be imposed. You fire the weapon during the forcible felony, then that's an additional 20 years on top of anything else that might impose. And if you uh, hurt somebody, if you strike somebody with the weapon, you fire it at somebody and you harm them. Actually, I'm sorry, if you fire the weapon during the felony, whether you hurt or kill somebody, you're still going to have a 25-year or life and possibly death sentence if you end up murdering somebody with a weapon. But folks, thank you very much for tuning in this evening to my presentation. And once again, like, share, or comment below. And once again, thank you for attending Legal Ease. And also, if you like, you can watch my YouTube channel, CDB Injury Law, where I post videos and commentary on various subjects. But once again, thank you very much, folks, and have a great evening and be safe.